Yep. David?
This is actually a bylaw merging the existing Cleanfill licensing bylaw of 2008 and the licensed waste handling facilities bylaw of 2007. So, as I said, a merging of those two bylaws, significant changes there are looking at actually defining what is hard fill and removing a lot of materials that may have provided potential for leaching into groundwater and causing public health issues. That was the main reason. There was a debate around the percentage of green waste that would be allowed in the hard fill that came in. There was we were proposing a halving of it. Went away from that. It was at, correct me if I'm wrong, was it 5%, Ruth? What was
the proposal was, which followed up from the previous review of the bylaw, suggested that at the next review, this one, the reduction in green waste should be reduced from 2% to 1%. But the panel decided to retain the 2%.
Yeah, we found it would be quite difficult to actually differentiate what's the difference between 2% in a truckload to 1% would be somewhat difficult. There are a number of changes that are allowing our team to actually regulate what's going into these landfills. There are some quite regulatory frameworks around recording of loads that enter these landfills and what's in them, and they have to be retained on file for a 12-month period and accessible for staff to review at any stage. So that's the main changes to that bylaw.
Very good. So I will, is there any discussion? Yanni?
Yeah, I think one of the other major points from this was around the requirement for a licence for the waste handling. And if you think about some of the operations, Sydenham, Springs Road, Kenaway, we heard evidence from our staff around ones that had got resource consents but actually hadn't got licensed through the process. So if council has the ability to have licenses, we can actually look at some of the other issues associated with those operations and just ensuring that it's best practice, ensuring that any relevant matters are considered, and that's really section under handling requirements for waste operations, 8.1. I wasn't sure that we'd agreed to move 8.1.b, but it says that it has been removed. So there's kind of general discretion that council have in terms of the licence, which I think is really important because council staff will get the opportunity to look at how those waste operations will be conducted, and if there's any concerns, they can obviously consider that through the licensing outside of the RMA processes, which, as we heard through the thing, didn't actually address some of the concerns that people may have. So I think this is a step forward. And I do think it's important that council staff do have the ability to consider the licensing of these operations so that the issues of non-compliance that we've had rise through the RMA can actually be dealt with in a more immediate way and hopefully get a better outcome for the way in which people are operating waste, which, as we know from Sydenham, can cause huge problem, concern in local communities around the impacts.
Okay, I'll put that motion.
Yep. On two of the aspects of this. The first is in the submissions from the Canterbury Aggregate Producers Group. What's the effect of this on what's allowed to go back into backfilling the quarries?
In effect, the bylaw makes it extremely clear what goes back into quarries is Cleanfill. It's very precise as to that. The Canterbury Aggregate Producers Group suggested that this part of the bylaw was actually unnecessary because it was handled under the Resource Management Act consent. So we did actually look through the conditions of the consents for the current consents, and it is clear that in actual fact, as supported by the Regional Council, that the bylaw is very useful in its precision and its focus in respect of Cleanfill simply on what is clean, what can go into the hole. It really, in respect of Cleanfill, and the monitoring and measurement of the amount of waste are the two aspects that it addresses.
Thank you. And what's the penalty for breaching this bylaw?
For breaching this bylaw, like most bylaws, there is not, you would have to take a prosecution. However, there are other ways of obtaining compliance, and one of the key tools that we have is actually apparently the possibility of removing their license. People do not, this, in order to have a license, that so there's that, and then there is the additional possibility of so a breach is, if you took a prosecution, there's a potential of a fine not exceeding $20,000. But going to aside from the prosecution route, which we all know is very rarely undertaken, there's a licence fee, which if additional monitoring is required, for example, if they are found to be not complying, they're charged additional money for that monitoring. So that's, so that's it. And there is also the threat to remove the licence, which is a reasonable.
Yeah, I think an enforcement officer did visit and found material in the at the face of the landfill that was not permitted. They could be instructed to remove that landfill load out of the hardfill. The landfill.
Is there any capacity for this in any way to cover demolition sites that have been backfilled with material that's potentially contaminated?
This bylaw doesn't deal with contaminated material because by definition it's not Cleanfill. And yes, it would not be, so that would have to be dealt with under other processes, and I'm really not qualified to address this.
Okay. Great, I'll put the motion. All those in favour say aye. Those opposed say no. That's carried. Thank you very much. That was excellent.